All right. Court of Appeal is before the Sixth District of the State of Florida is now in session. The Honorable Perry and Wozniak have been presiding. All persons having been before the court of law may give attention and you will be heard. May God save the United States of America, State of Florida, and this honorable court. Please be seated.
Good morning and welcome to this session of the Sixth District Court of Appeal. My name is Carrie Ann Wozniak. I'm the presiding judge today. I'm from Orange County. To my right is Judge Roger Ganim, also from Orange County. And to my left is Judge Steve Berlin from the Sixth Judicial Circuit. We're happy to have him today as an associate judge on our court. Just a reminder that we are being recorded today. We're going to be having one in-person oral argument and then one Zoom oral argument, and they will both be recorded. And so we will go ahead and get started with our first case, which is 23-2983. Navy Federal Credit Union versus Surf Consultants, Inc. and Ami Griffin. Appellant, you ready to proceed? How much time would you like to reserve for rebuttal?
Your Honor, I'd like to reserve 5 minutes of my allotted time for rebuttal.
Okay, great. Thank you, and you may begin.
Good morning. May it please the court, Patrick Ayers on behalf of the appellant, Navy Federal Credit Union. We're here today to ask this court to reverse the final judgment and garnishment entered against Navy Federal Credit Union by the trial court because that court lacked jurisdiction over the assets sought to be garnished. The essence of garnishment is the res, the asset. It's not about people so much. It's about the res and where that res is located. And here, that res, the asset sought to be garnished, are deposit accounts. And by virtue of the agreement between the member judgment debtor and the garnishee Navy Federal Credit Union, that account, or those accounts, excuse me, are located in the state of Virginia and not in Florida.
Counsel, let me ask you, isn't there a difference when we're talking about property, a difference between the bank account itself and the deposits credited to that account, such that the deposit is a debt owed to the depositor by the bank, whereas the account is some other bundle of rights that the deposit or the account owner has, the right to online banking and the right to, checkbooks and things like that. Aren't we talking about two different assets?
Yes, we are, Your Honor. And I'm glad you brought that up because as we pointed out in our brief, while there are certainly characteristics of a debt, as you point out, it's really the money that's put in, the obligation back, that's the debt. But the bank account itself is a different asset. And I'm unaware of any court that has treated or accorded a bank account as a debt. In fact, it's more treated as a tangible asset, something that can be physically seized, as we saw in the Fourth District Court's appeals decision in the Burns case, which essentially, in the eyes at least of the Consumer Financial Protection Bureau, created where we are today by defining Florida as a restriction state. But the simple answer is yes, bank account is all those bundle of rights. It's part of the agreement that the member has with the credit union. And while the credit union gives the member the right to receive funds or access funds really anywhere, remotely, it doesn't mean that you can garnish anywhere.
And in this case, Surf Consultants, as I understand it, they don't want to fill out a signature card and get an ATM card and act like they're the owner of the account and make deposits and make withdrawals. They just want the funds that are credited to that account. Isn't that correct?
Yes, I don't disagree with it.
And so in that respect, why does it matter where the account is as opposed to the obligation to pay the funds in that account? In other words, if those funds are due on demand in Florida, isn't that the answer to the question, regardless of where the bank considers the account to be located?
No, I don't believe so. And again, it's because it's more, it's the bank account. It's something more than just the debt or the obligation. And they stand in the shoes of the judgment debtor. They're not entitled to get an ATM card. I mean, why don't we just hand them an ATM card and they can go to wherever and get the money? That's not how it works. Garnishment, unlike many of the other cases that we see involving personal jurisdiction, requires jurisdiction over the res. And here, the agreement creates that account. Without that account, without that agreement, there is no account. We're not here today. That defines it, creates it, governs it. And Navy Federal Credit Union and the member agree that at the time it was created, it's located in Virginia. It's been maintained in Virginia. That's the nerve center, the operational center for Navy Federal Credit Union. In today's modern world of banking, the branch doesn't have autonomy. And that's true for most every financial institution. It's a centralized operation. The nerve center for Navy Federal is in Vienna, Virginia. That's where the funds come from. There's very limited funds maintained at the branch today. Back in the day when we first started out in this process, you banked at your local neighborhood or community branch. That's where you walked in. That's where you opened and established the account. That's where you went in and got your funds. Well, there's very limited funds here today. It's all done on servers. Those servers for Navy Federal Credit Union are in Virginia. So again, the res matters. If we weren't, but for the judgment creditor serve consultants in this garnishment, I don't think we would care about the fact that the agreement establishes the location as between the judgment and Navy Federal Credit Union being in Virginia. Why would we care? It makes sense. It's their contract, their agreement. They've agreed to do that. There's a rational basis for Virginia. As I said, that's the headquarters, the nerve center, the operational center. Branches don't have autonomy. If you walk in with a court order today saying release these funds, the branch isn't going to do it. Like it or not, it's going up the ladder. It's going to the operational center for somebody to review it and say, yes, this is a valid order. We need to comply. It's one of the reasons why the legislature changed the statute 15, 20 years ago to provide an extra business for financial institutions to respond to the writ. Because the decision is not made at the branch level. It's made by the operations center, that nerve center, wherever it may be. Every financial institution has some type of legal order processing center. Usually it's one of their, either where they're headquartered or some financial center. So it is very important. And Florida jurisprudence has consistently provided that if the res is not within the territorial limits of the state of Florida, Florida does not have jurisdiction over that res.
Can you address the Shim case from the Supreme Court? I mean, from what I'm taking from that is federal, the court had personal jurisdiction over Navy Federal. You don't.
We have never disputed that. So the international shoe cases, we don't, no dispute.
Okay, that makes sense. And so the Shim case is saying, well, if the court has personal jurisdiction, it can direct an entity to do something with property outside of the state. So why doesn't Shim cover the situation?
Because that's not a garnishment case. And garnishment cases we've always had in Florida needed to have in rem jurisdiction. Garnishment is quasi in rem, which means personal jurisdiction over the garnishee, undisputed here, and jurisdiction over the res. In Shim and in all those cases that preceded it, Advanced Petroleum, Shank, Belia, none of those were garnishment cases. None of them. The res was not the essence of those cases. Let's compare and contrast Navy Federal as garnishee and the judgment debtors or defendants in those cases. Navy Federal is not a defendant or a judgment debtor. It's only here today because the legislature adopted Chapter 77, the garnishment statute, which is in derogation of common law. It's a statutory creature that governs and controls the process here. Nothing in Chapter 77 says anything about personal jurisdiction alone is sufficient. Chapter 77 addresses the what, the when, and the how, not the where. There's nothing in there. Florida jurisprudence addresses the where. It's got to be within the confines or the territorial limits of the state of Florida. And in this instance, because of the agreement, and I acknowledge, if we don't have that agreement, we're not here.
So I have a question about the res. It's a hypothetical. Navy Federal Credit Union member walks into the branch here in Orlando, comes with a bag, sits on the counter, slides $5,000 to the teller, says, I want to make a deposit. The teller says, thank you very much. Says, here's your receipt, deposit's been made. Here's your deposit slip. At the time, right at the moment, the deposit slip's handed back. You hear someone at the door says, there he is, officer. There's the man who stole my purse, and that's my purse. It's laying there right at the teller's window. And the credit union member says, that's right, officer. I took her purse. I took her money. I've deposited it. You say, give it back. He says, no. Where is that $5,000?
It's the bank's property at that point. That doesn't mean there's not claim to it or a right to get it back or some payment. But once the deposit is made, it becomes the bank's property, the bank's money. And it has, yes, an obligation, should that customer come back in and request, I want so much of it back or all of it, they're obligated to pay that. But once the deposit's made, it becomes the property, in this case, the federal, Navy Federal Credit.
Thank you.
Back to, further distinctions over Shim is besides the fact that it's not a garnishment case. In fact, none of those were, where the res was the essence of the case. Personal jurisdiction did matter. In those cases, the defendant or judgment debtor didn't do something that they were required to do or should do. And the court, because of its personal jurisdiction, could compel them to do that. And what, as I said, Chapter 77 doesn't have, in Shim, we're looking at Florida Statute 56.29, proceeding supplementary, which has very broad, explicit powers granted to the court to aid a judgment creditor in getting the relief that it seeks. Chapter 77, which the court must strictly construe, lacks those broad, expansive powers. And if we're going to now graft on Chapter 77 an expansive power, well, we can reach out-of-state assets, absent explicit statutory language, upholding them. I think that's violative of the principle of statutory construction and strict construction.
Counsel, what about a scenario where Ms. Griffin here had loaned money to a friend in Florida, and then that friend takes the funds, deposits them in a bank in Virginia on a trip to Virginia, but then returns to Florida. Surf Consultants gets a judgment against Ms. Griffin, and then serves a writ of garnishment on the friend, identify all indebtedness that you owe to Ms. Griffin. And the friend says, yeah, I owe Ms. Griffin $5,000, but I deposited that money in my account in Virginia. Is it your position that the friend would not be obligated under Florida law and that writ of garnishment to pay the debt to the judgment creditor because that's a debt owed to Ms. Griffin in Florida and the obligation arose in Florida?
It's going to depend on whether, if Florida has jurisdiction over her, again, because now she's in the position of being a garnishee. Florida must have personal jurisdiction over her.
Yeah, I assume Florida does. That
Okay.
She's a Florida resident. The loan was made here. The promissory note is payable on demand in Florida. Wouldn't that creditor on that note be obligated to pay the judgment creditor on that writ of garnishment?
And I think, yes. And again, but that's a different kind of debt than a bank account.
Well, but see, I go back to like the early cases in Florida. We have, for example, Glidden v. Gutelius, if I'm saying that right, in Florida in 1928. It says that a general depositor, when making a deposit in a banking institution, parts with title and becomes simply a common creditor to the bank of that amount. If the bank is just a common creditor as a result of that deposit, why is the bank's situation any different from a personal loan made to a friend? It's just a debt that's payable in Florida. Why aren't those situations treated the same?
Again, in my view, it's because we're dealing with a bank account as opposed to a note or a loan obligation, whether it's written or oral.
But we already established the account separate. In this case, even I think in the garnishee's in the bank's written papers or the credit unions, we can give you all but $5 because we got to hold that back so the account stays open. In other words, the judgment creditor doesn't want the account. The judgment creditor just wants the money, just wants to step into the shoes of Ms. Griffin in terms of the obligation owed by the bank to her. It's just a general debt under Florida law, unless you tell me there's something in the agreement that changes the nature of that debt.
I can't say that there's something specific that would address that particular situation in the agreement that would make it any different. But again, maybe we're not connecting on it. And I understand what you're questioning or raising about the debt. But again, I view, and again, no court has accorded a bank account for garnishment purposes as that general debt obligation. There's something more to it. Location does matter. You can go back to 1845, which is the earliest I could find of Florida adoption of the garnishment statute, and indebtedness and debts have always been part of the statute. You know, why then somewhere along the line has not some court addressed a bank account differently, or in this case, a deposit account, credit union, not a bank, differently? Why hasn't it been done then? I understand that under the practical, you know, the plain language, that there's characteristics of a debt here. But we've got an agreement that says these funds and the accounts have always been maintained in Virginia. They're located in Virginia. There's nothing that precludes the judgment creditor from going there to domesticate the judgment and garnish the debt. Because jurisdiction over the, in this case, Miss Griffin, doesn't matter for purposes of quasi in rem jurisdiction. They have jurisdiction over her because that's where the account is. That's where the funds are. If we can now garnish anywhere and everywhere that a financial institution has a branch or funds are accessible, shouldn't that be perhaps the legislature's decision to expand or modify Chapter 77 to provide that? Again, there's nothing explicit in Chapter 77 which governs this procedure. We're only here because of Chapter 77. At common law, third-party creditors had no rights against, in this instance, the Navy Federal Credit Union. Is that my?
You're into your rebuttal time.
Okay.
You can use it now or later.
I will reserve the rest.
Okay, thank you.
Thank you.
You may proceed.
May it please the court. My name is Ryan Spreckman from the firm of Spreckman and Fisher, PA, counsel for the appellee, Surf Consultants, Inc. The other appellee, Amy Griffin, did not participate in the garnishment proceedings, does not participate in this appeal. This case is about whether Florida courts have jurisdiction in garnishment over accounts held by a Florida resident, open in Florida, and utilized in Florida. The appellant's position is that a judgment debtor and garnishee can contract away the Florida court's jurisdiction by deeming the account be located somewhere else. However, as the trial court agreed, Florida courts do have that jurisdiction. Now, there are a number of cases cited by both parties in their briefs on discrete piecemeal topics that make up our arguments. But as far as I know, there are 3 cases in this state that address the exact same topics that are before this court. And that also provided reasoning, and all agree with our position. The first is Ohio Casualty Insurance Company versus Darrell Blackman Concrete from Duval County. That was with the same exact garnishee, Navy Federal Credit Union, who made the same exact arguments. It had a nearly identical procedural history. That case, the judgment debtor was a Florida corporation who opened the accounts in Florida and utilized the account in Florida with no connection to Virginia.
Was that case appealed?
No, it was not appealed. And the Navy Federal Credit Union paid on that final judgment and garnish. That court, in its reasoning that, again, as the court pointed out or asked, was not appealed, found that the account was located in Florida and was subject to jurisdiction in the state, that the garnishment was based on indebtedness and it was subject to garnishment regardless of its location, that the court could compel the garnishee in transferring the debt to the judgment creditor, as the court pointed out in Shim, and that the court was not bound by the CFPB order. Second case was ViStar Credit Union versus Kelly also from the Duval Circuit Court. That was also with the same exact garnishee, Navy Federal Credit Union, making the same arguments, also with a nearly identical procedural history. That case had a Florida resident, opened the account in Florida and utilized the account in Florida with no connection to Virginia, just like the facts before this court. That court found that the account was located in Florida. There was a separate issue that the court ultimately dissolved the writ of garnishment because it determined that the indebtedness was not to the judgment debtor, but instead was to a third party. The third case is Superior Debt Recovery versus Eskridge from Broward County. Also with the same exact garnishee, Navy Federal Credit Union, with a nearly identical procedural history. Just like the facts before this court, it was a Florida resident who opened the accounts in Florida and utilized the account in Florida with no connection to Virginia. The court there found that the account was located in Florida and subject to garnishment in Florida, that the garnishment was based on indebtedness and was subject to garnishment regardless of location, that the court could compel the garnishee to act in transferring the debt to the judgment debtor, to the judgment creditor, and was not bound by the CFPB order. to get on the question there was also no appeal in that case. And there was a satisfaction of judgment and garnishment issued, presumably meaning that the bank paid.
So this is the only case that's on appeal in the state that you're.
That I'm aware
on
of,
this
yes.
issue. Okay, and I'll ask you on rebuttal, same question. Okay.
Yes, as far as I'm aware, this is the only case on these exact facts that were presented through the bank's answer to the writ of garnishment that is on appeal. Yes.
Counsel, let me ask you, should we affirm the decision of the court below, what would be the appropriate rule of decision that we should announce? In other words, is it necessary that the funds be accessible on demand in the state of Florida? Is it necessary that we make a finding that the account is located in Florida as opposed to Virginia as provided in the agreement? Or is there some other principle that we should make our decision on? You know, the case law does say that this is a quasi in rem situation, so there must be some res in Florida. What is that, and how do we articulate that in a rule that would not only apply in this case but in future cases?
So to begin with, if the court does determine that the account was located in Florida, it doesn't even need to address the other issues because the accounts would be subject to garnishment in Florida because the account would be located in Florida and therefore the res would be in Florida. But to address your question on a broader issue of what maybe kind of limitations would there be and how the court could kind of provide a rule on how garnishment would go forward based on garnishment being indebtedness. There was a case from the Minnesota Court of Appeals, Nagel v. Weston, that was cited in our answer brief on page 35 that may be instructive there. In that case, it was a judgment from the California court for the judgment debtors moved to Texas. The judgment creditor then domesticated the judgment in various jurisdictions around the United States, including in Minnesota, despite the fact that the judgment debtors had very little connection to Minnesota, nearly none. In that analysis from that court, I think would provide a proper rule for how garnishment could go forward in this state. In that case, the court said, quote, although appellant's contacts with Minnesota may be limited, we are satisfied that Minnesota's exercise of in rem jurisdiction to enforce respondents' existing foreign judgment comports with due process. By opening and maintaining their Ameriprise account, the appellants engaged in purposeful activity related to Minnesota that makes the district court's post-judgment exercise of in rem jurisdiction fair, just, and reasonable. We do not suggest the respondents could garnish and attach appellant's Ameriprise account consistent with due process in any state where Ameriprise does business, but maintenance of such a suit in Minnesota where appellants knew Ameriprise to be headquartered does not offend due process. So basically what they did was determine that the res was located in Minnesota because the accounts were available in Minnesota, but also had a minimum context test for determining whether the judgment debtor would be subject to garnishment in that state. I hope that answers your question, Your Honor.
Well, let me just kind of flesh that out. There's various scenarios in all the cases that have been cited to us. So suppose Navy Federal had a single business office in the state of Florida, had a registered agent for service of process that you could get in personal jurisdiction, but didn't do any business with customers, didn't have any branches, didn't, accept deposits and pay on those deposits in the state of Florida. Would that contact with Florida be enough for a Florida judgment creditor to serve a writ of garnishment on Navy Federal, just based on the fact that the judgment debtor, had an account with Navy Federal somewhere, and you just happen, they just happen to have an office in Florida that the judgment creditor could get to? Would that be enough to then compel Navy Federal to produce deposited funds that weren't deposited in Florida, were done somewhere else, just based on the fact that Navy Federal had an office in Florida?
Well, I think part of the question there would be whether the funds are accessible in Florida. So if they just had a registered agent office in Florida, not a branch or anything like that, I think that it would be proper. Or if it just had a registered agent office, I would understand having a limitation there.
In other words, the customer can't go to the registered agent and say, I'd like to withdraw my funds. So
Exactly.
if there was no right to withdraw the funds in Florida, would you agree that could be a problem for a writ of garnishment?
Yes, exactly. I think that would be a reasonable limitation there. And also is kind of what I described in that Minnesota case is that there would also, there could also be some sort of minimum context test for the judgment debtor for if they even had any sort of reason to subject themselves to the court's jurisdiction.
What if the deposit was made in another state, but Navy Federal has a branch in Florida, and the depositor having deposited those funds in some other state, then moves to the state of Florida, gets a judgment against her, but has never done business with the branch in Florida? Would the mere ability to go into a branch and make a withdrawal be enough for a judgment creditor to serve a writ of garnishment on Navy Federal and garnish, those funds in the state of Florida?
Yes, I do believe so, Your Honor. And in to kind of tag on to that, it would be a very unusual situation where a account holder moved to a state and had no interaction with the account from that state. Presumably, there would be some sort of debit card where they would be making transactions from the state where they reside or having some sort of interaction with the account. But even if it were the kind of extreme situation where they had just moved to Florida, and really had no interaction with the bank there, but were able to withdraw the funds there, yes, I do think that it would be subject to garnishment in Florida.
And in that situation, is the res that would support this quasi in rem jurisdiction, is it that the obligation to pay the funds on demand, or is it the account?
I think, as you pointed out before, it would be the obligation to pay the funds because what the Florida statutes address is indebtedness, not an actual specific account. And to kind of go back to the Minnesota case, it does have a little bit of discussion about the res being in Minnesota, despite the fact that the judgment debtor had no deposits in Minnesota. It was just at the accounts that the bank's headquarters was located in Minnesota. In that case, the Minnesota Court of Appeals says the basis of in rem jurisdiction is the presence of the subject property within the territorial jurisdiction of the foreign state. Tangible property poses no problem for the application of this rule, but the situs of intangibles is often a matter of controversy. A debt is a property that may serve as basis for in rem jurisdiction. And the jurisdictional rule of Minnesota has long been that a debt owed by a garnishee to an out-of-state garnishment debtor may be attached to Minnesota so long as 1, the garnishment debtor could sue the garnishee in an action on the debt in Minnesota. 2, Minnesota garnishment law authorizes the attachment. And 3, a Minnesota court acquires jurisdiction over the garnishee. And in doing so, quoted a separate case from Minnesota saying, quote, for the purposes of attachment, a debt has a situs wherever the debtor or garnishee can be found. Wherever the creditor or judgment debtor might sue for its recovery, there might be attached to his property, provided the laws of the forum authorize it. And then later in the case, after noting that the U.S. this is all in comports with Florida or U.S. Supreme Court law, it says, because appellants could have sued Ameriprise in an action regarding their account in Minnesota, Minnesota law authorized the attachment of the account. Ameriprise was subject to the district court's jurisdiction. The district court had in rem jurisdiction in under the jurisdictional rule governing attachment of debts. So yes, I believe the fact that the bank's located there, that they can access the accounts in there and therefore could try to collect on their debt in the state would give this state in rem jurisdiction over the funds. To go back to my argument, so in addition to the final judgment below, there are 3 cases. Those are the 3 cases that I talked about, and on the exact issues before this court, and they all agree with our position. To look at more of the details here, these accounts were located in Florida. This is a Florida resident who opened the accounts in Florida and utilized the accounts in Florida. The appellant simply cannot point to any authority that supports the idea that an account opened at a branch in Florida, accessed in Florida, utilized in Florida, and owned by a Florida resident is somehow not subject to garnishment here in the state of Florida. The appellant instead wants to look at the account agreement between the judgment debtor and the appellant with no further analysis to the exclusion of all other facts. Other factors used in other cases in the state were 1, the residence of the account holder. That was in Code Ventures v. Vital Motion from the Southern District of Florida. Number 2, where the accounts were open, also from Code Ventures. And number 3, deposit slips, account opening documents, and other similar information. That was in both Power Rental Opco v. Virgin Islands Power and Water from the Middle District of Florida and Stansell 2 from the Southern District. So applying the facts before this court to those factors, there's no doubt that the judgment debtor resides in Florida, and there's no doubt that the account was opened right here in Orlando in the state. Therefore, the account is located in Florida for the purpose of jurisdiction and therefore is subject to garnishment.
Sir, I have a question. Counsel for Navy Federal mentioned that servers were in Virginia. Is that stipulated into the record, or was that an assumption?
That servers were, I don't recall that being stipulated to, but I believe it was stipulated to that the headquarters of Navy Federal Credit Union is in Virginia. So I suppose that would be a reasonable assumption.
So what if the servers were on the cloud and the data was stored at some sort of data farm, say in Wyoming? And so but we have the fact pattern here where you have the judgment debtor having an account in Florida. You have the headquarters in Virginia. Within Wyoming, with the data at a server farm, data farm, would they have jurisdiction?
I think that I would answer that similarly to how I answered Judge Ganem, which is that the most important thing is whether the judgment debtor can collect on the account in that state. Clearly, the judgment debtor here can collect on the account here in Florida because she opened the branch here in Florida, opened the account here at a branch in Florida, and there's no doubt she can go into a Florida branch and collect on her funds. And as I described in the Minnesota case, the court also there entertained a minimum context test for the judgment debtor to see if that judgment debtor had any reason to avail themselves of that state's jurisdiction. And I think that would be reasonable in this situation to say that the judgment debtor would need to be able to collect on the funds in that account and to have had some reason to be put into that jurisdiction. So as I said before, what the appellant here is wants the courts to ignore the facts about the location of the account and only look at the account agreement. But that account agreement is not binding in this situation. The judgment creditor is not a party to that account agreement. And Florida law is clear that account agreements only bind parties to that agreement.
What if the agreement, and you correct me if I'm wrong, I believe the agreement in this case, and I might be getting confused with one of the other cases, but has some kind of provision that if you want to withdraw all of your funds, you must give some notice, like 30 or 60 days to the credit union. In other words, you can make withdrawals whenever you want, but if you're going to take all the money, we want you to give us some notice. Would that provision in an agreement also be applicable to a judgment creditor serving a writ of garnishment who wants to essentially stand in the shoes of the judgment debtor and access those funds?
No, I don't believe so. In standing in the role of the judgment debtor, we're talking about jurisdiction here. We're not talking about construing a contract between the two parties to that agreement. It would be one thing if the judgment debtor had some sort of controversy directly with the bank where the two parties have an agreement. But in determining jurisdiction, I don't think the account agreement would be relevant. And to kind of address that about staying in the shoes of the judgment debtor, where the case is cited by the appellant for the proposition that the judgment creditor stands in the shoes of the judgment debtor and can only assert the judgment debtor's rights. What the appellant actually here wants to do is to put the judgment creditor in a lesser position than the judgment debtor. There's no doubt that the judgment debtor can go into a bank here in Florida and have access to the funds. But what the appellant wants to say is while the judgment debtor can go into a bank and have access to the funds, the judgment creditor has no access to the funds here in Florida. Applying the facts from our case that the judgment debtor lives in Florida, open the accounts in Florida, and accesses the funds in Florida. This account is clearly located in Florida. And if the court agrees with our position that the accounts are located in Florida, it can stop its analysis right there and can affirm the trial court's judgment. All the other issues are only relevant if the court determines that the account is located out of state. So now one other discussion raised by appellant was, or an issue that was raised, I think, by the court was about the language of the garnishment statutes. the plain language of the garnishment statutes, under the plain language of the garnishment statutes, garnishment in Florida is based on indebtedness. There's chapter or section 77.01 of Florida statutes. It subjects, quote, any debt due to defendant by a third person, or quote, any tangible or intangible personal property of defendant in the possession of a third person to garnishment. As the court noted, the relationship between account holder and the bank is that of debtor creditor. This was highlighted by the Florida Supreme Court in Malaby Tunnicliffe when it said, quote, a bank and its depositors sustain the relationship of a debtor and creditor to each other. This was even acknowledged by the appellant in its amended answer of Garnishee in saying, quote, Garnishee was and is indebted to defendant based on the following accounts. And unlike indebtedness, there's nothing in the garnishment statutes about the location or property of the account. Instead, the appellant wants the court to step into the role of the legislature and add that location component to the garnishment statutes. So in conclusion, for the appellant to prevail, it would need all the following. For the court to find that the accounts are located outside of the state of Florida, despite the relevant facts, that the location of the account even matters, despite the nature of its indebtedness, and that Florida courts cannot garnish out-of-state accounts. If the court agrees with our position on any of those three issues, then the accounts are subject to jurisdiction in Florida and are subject to garnishment in Florida, and the trial court's judgment should be affirmed. These accounts are clearly located in Florida because the judgment debtor resides in Florida, the accounts are open in Florida, interacts with the accounts in Florida, and has no connection to Virginia. The appellant's indebtedness to the judgment debtor is subject to garnishment under the plain language of the Florida garnishment statutes, and Florida courts have power to compel a party like the appellant to act. Therefore, I respectfully request the trial court affirm the trial court's judgment. I respectfully request that this court affirm the trial court's final judgment. If the court has any other questions? Thank you for your time.
Thank you, counsel.
Responding to your question, this is the only appeal on the issue. None of the
Okay,
other cases.
statewide, okay. Thank you.
In order for appellees here to get where they want to be with all these other compelling facts, which they're compelling, you've got to ignore or discount the underlying agreement that created and established the deposit account. Seemingly, that's what the trial court did. And all the cases that we've cited, the Florida federal court cases and whatnot, apparently an agreement providing a location was not available to those courts. And they struggled to come up with what are the relevant indicia. What better indicia than an agreement that says the location is fixed? You avoid the myriad of variables that go along with, well, where is it maintained? Where is it accessed, et cetera? What happens if it's opened in a particular state? Customer moves away. Or the bank or the financial institution closes a branch, or later opens a branch in the state. The contract, the agreement here is central to the existence of the deposit account. It avoids those myriad of variables, gives simplicity and clarity. Chapter 77, its plain language says nothing about where the res has to be. Nothing in that statute says just because there's a debt or there's tangible and intangible personal property in the possession of the garnishee, does that mean the Florida court has jurisdiction? It's got to be within the confines of the territorial limitations of the state of Florida. Florida jurisprudence for hundreds of years has made that very clear.
Counsel, in the absence of a statement in the account agreement as to where the account is located, if the location of the account is important, how would we determine that?
Well, I think then if we don't have the benefit of an account agreement that specifies, you're going to do exactly what all the other courts in Florida have. You're going to have to look at those other indicia. But again, those themselves are subject to variables over time. It's, again, perhaps it's something that the legislature may need to address or should address in Chapter 77 to make it clear so that we have more certainty. In Navy Federal's view, by having the account agreement designate the location, it solves a lot of problems. It avoids a lot of the conflicting and differentiating laws that exist in many of the jurisdictions where it does business, where it has branches. This gives it uniformity, another benefit of having the account agreement specify the location.
So who could garnish this money under
Well, if it's in Virginia. as we
Only Virginia judgment holders?
No, appellee could domesticate the judgment in Virginia. And if the account is in fact, as we say it is in Virginia, that's where it would be subject to garnishment.
Okay, so you'd have to domesticate the judgment and collect on it
That's right.
only in Virginia. Okay.
I mean, if we start talking about, well, accessibility and availability of funds are anywhere and everywhere, again, I think that's something that the legislature should expound. I don't think it was intended that for garnishment. Again, maybe the law hasn't caught up with the modern day realities of banking. Everything was pretty much centralized with the branch. Now it's with servers. Funds are moving digitally and through cyberspace. We haven't addressed it, I don't think, as a state, and I think many states haven't either.
Could the legislature of Florida, assuming that, as I believe to be the case, garnishment is determined under state law. I think even the federal courts look to the state law
Yes.
where they sit. Could Florida legislature say, irrespective of what a deposit agreement says as to the location of the account, if you've got a branch in Florida, you're subject to a writ of garnishment in Florida? Could the legislature make a rule like that would be binding on the bank or on the credit union without violating any constitutional or other principles?
I was going to raise that question. I'm not sure, but I would think the answer to that is yes. I mean, maybe they could engraft upon the statute sort of this totality test that the trial court seemingly used, even though there are no cases that hold that way. You look at the totality of the circumstances. We look at the majority of the facts, and that's how we determine the location. So yes, in answer to your question, Judge, I think yes, the legislature could graft that onto the statute. This is what we're going to do. Bank accounts are a different animal, a different type of asset, a different type of debt. This is how we're going to accord them for purposes of garnishment. Garnishment itself, derogation of common law, very different statutory remedy, otherwise available to these creditors in the courts in the Shim case and its project. Thank you very much for your time.
Thank you, counsel. We will be in recess until we start again at 10 o'clock for our Zoom oral argument.
All right.